Tiffany Hill's in your waiting room?
I don't see her yet, Mr. Lindenbank. I'm waiting for her.
I'll call her back again.
And while you're doing that, Mr. Lindenbank, if you can just tell me briefly, look, I reviewed the paperwork and it looks like you're just simply asking for some FaceTime access and phone access during Mr. Milburn's.
Does not see
Yes, Your Honor. He has got custody of her till the end of July on makeup time, and there's no provision in there for any contact with his 3-year-old mom. If you look at our exhibit 22, it shows a call log of all of the times my client has reached out, trying to video chat, trying to talk, trying to have some contact with her daughter, and it's never answered. So since we were in court that day, her mother has no clue of how she is. And she should have some kind of contact, some kind of visitation that she denied her. Mr. Milburn, we understand, but
no, I know, but two wrongs don't make a right, and
yes.
and so we need to get Ms. Hill on here because I don't want to repeat myself, you know, and say stuff more than once. So if you can just check with her, and once we get her in the room,
apparently she's been trying to call in, and every time we call her, so
I know we had that same thing for 7.5 months. You know, that's parental alienation. I mean, 3 times. I mean, what would you say for that? We actually are following a conditional bond. Okay, I think Ms. Hill actually knew that, and Ms. Hill does a lot of this knowingly. This is knowingly. She already knows that she's not supposed to have contact with my phone, any of that. Okay, she already knew that.
We're not going to argue the case until we're on the record.
I can get arrested for that
because I don't want to hear this case twice. So we're going to argue it once we get Ms. Hill here, and we're on the record.
Is he on the phone?
Hello, I'm here.
All right, Ms. Hill, if you can get your video up and running, we're going to get started.
Okay. Okay.
All right, I just want to say a couple of things before we get started, because my hope is that we may be able to get an agreement on this without needing to have a long, exhausted hearing. I can tell you, Mr. Milburn, that it is this court's preference that each parent get time with a child. I think that's very important. And I know that you went an extended period of time without seeing your daughter. And I understand that. And it finally was filed in a way that I was able to remedy that and get you some makeup time. But here's the thing I want to make clear this morning. I'm not a fan of one parent not letting another parent see a child or talk to a child or check on a child, because it is in your daughter's best interest that her mom be very involved in her life and that her dad be very involved in her life. I can tell you as a judge, if things are filed properly, I'm always going to make sure that happens. And so what I said earlier before Ms. Hill was on to Mr. Lindenbank is two wrongs don't make a right. What I mean by that is, if someone does something wrong, you address that, you bring it to the court's attention, and let the judge remedy it or try to fix it. You don't take the law into your own hands and just not let the other parent see the child. And that's one of the reasons Ms. Hill is having such a long period of time without seeing her daughter, is because I felt like she kind of took matters into her own hands. And as a judge, I don't want that happening. Mr. Milburn, I can tell you, if she calls to talk to her daughter, we're going to make that happen. And she's going to talk to her daughter. And if you don't let her, and I understand there's issues with the protective order, and we're going to address that in a second. We're going to make sure we do this in a safe way. But if you don't let her talk to her daughter during your extended periods of time, there's going to be consequences for that. So we're going to figure out a way today that when mom wants to talk to her, she's able to do that, because that's what I want. And I'm going to make sure that happens. And if we're back here in a week and she says, well, now I'm trying this new safe way to talk to my daughter and Mr. Melvin's not letting me, then I'm going to alter things. And I don't want to do that, but I'm just letting both sides know I'm taking this stuff very seriously. I don't want one parent keeping a child away from another parent, whether it be electronically, whether it be physically. That's not what's going to happen. If there's a basis for us to keep a child away from another parent, there's going to be a trial, that evidence is going to be presented, and then we'll make a decision on that. So what I need today from the parties is I want to know of a way, and I'm sorry for my cough. I'm getting over a lung issue and it's just taking a long time. But I want to figure out a way that Mrs. Hill can contact Alana and talk to her, or Elena and talk to her. So, Mr. Milburn, do you have a iPad or a phone? If I give her a certain period of time per day where she can talk to her daughter, where that phone can be made available for FaceTime access. It can be your wife's phone. It can be your wife's iPad or some other mechanism, so that there's no Miss Hill calling your direct phone number. But I need a number where she can call and talk to her daughter. So do you have a number available for that to happen?
Man, it had to be the only number that I could possibly think of with safeguarding me, because this is not safeguarding me in the criminal proceeding. That's all I'm gonna tell you now. This ain't nothing. She done this before with retaliating, co-parenting, and next thing you know is you running back and
Yeah,
forth.
she's non-responsive, Your Honor. It just needs a phone number, a Facebook page, or something.
Sustained. Yeah, what I'm looking for, Mr. Melbourne, and here's the thing. I'm a district court, and I can sign stuff that will tell another judge, this is what we're doing, because I have family court jurisdiction, and that means that I have the ability to take your daughter away from you tomorrow or today and give her to mom. And I'm not going to do that unless I get resistance on mom being able to talk to her daughter on the phone. So what I need from you today is I need a phone number, and I'm going to put it in an order so that it protects you, because I understand you've got a criminal case pending, and I don't want to do anything that can harm your criminal case. But I am going to make sure that Miss Hill gets to talk to her daughter during your extended summer possession. So I just need a phone number, and I'm going to put it in an order so that no other judge gives you trouble. But I need a phone number that Miss Hill can call to talk to her daughter.
She can call my number, but we're trying to make sure everything is safe, and I think she understands that. Okay, and I'm starting to understand a lot of stuff even more clearly because when you said what you just said on these conditional terms of a proposed order, I mean, during the times of my possession, the last time, even before then, this is the third.
Judge, once again, non-responsive. You asked for a number, and
Sit
Mr.
down.
Milburn is
Hey,
giving
hold
us
on.
the usual around the bush.
This is not
Stop.
around the bush. This is about how many times, Miss Hill, that you know that she done concealed a child in parental alienation with custody interference. These
Well,
laws have been violated. and
Mr.
ain't nothing
Milburn,
happened, Miss Hill.
Mr. Milburn, that's why you have 2 months with your daughter right
2
now.
months, sir. No disrespect, but 2 months does not that's not punishment. 2 months. What about 7 months? It's 22 months. I have not seen my child, and she's 3 years old. I guess that's supposed to suffice for a punishment.
No, well, yeah, it's punishment. Part of what I did was punishment to get Ms. Hill's attention, but I can tell you that you can consult with the lawyers about other things that parties can file. But today we're here on a motion for telephone access, and that motion is going to be granted.
She can call my
Because
number.
there's no reason that the mom shouldn't be able to talk to her daughter and FaceTime with her daughter. And I understand. I believe me, I understand you're frustrated that you didn't see your daughter for a really long period of time. It upset me as a judge that was happening, and many times you would come in front of me and the paperwork wasn't correct for me to address it. And it got very frustrating for me. And as a judge, I very rarely lose my temper, but I remember in this case being frustrated because I don't like what happened. But I can tell you that I certainly don't like that a parent would have that done to them and then decide, well, let me get back at her and not let her talk to a child. Because that kind of stuff, to me, is like a parent acting like a child. And I don't want that. And so that puts me in a really difficult situation as a judge when I have parents that start acting like children and saying, well, since she did this to me, I'm going to get her back. That's not what's best for your daughter. And if this stuff continues, neither mom or dad is going to like this court because I'm not going to put up with it. It's not what's best for her. And I'm trying to get that through both mom and dad's brains. I want this child to be loved and cared for by her dad, and I want her to be loved and cared for by her mom. You two don't have to be best friends, but you need to at least be able to transition your daughter from mom to dad and back and forth without any kind of conflict.
Your Honor, there is no conflict when you follow an order. And in any event, on this side right here, we done follow every order possible. We got signs of neglect and abuse that we go ahead and try to acknowledge. Okay, when I got my child,
Do what the judge say
May
do.
I ask Mr. Milburn a few questions, Your Honor?
101
Yeah.
people.
All right, let's do this.
All on her neck.
Mr. Melvin, hold on.
Talking about care. You know, we really over here trying to understand for the life of us why Alana always has to have marks on her of neglect. You got marks in her.
Mr. Milburn, objection to your diatribe. You're not answering the question. Give us a phone number.
All right. I muted Mr. Melvin for a second because here's what we're going to do. We're going to conduct ourselves. We're in a courtroom, even though we're on Zoom. So we're going to all conduct ourselves professionally. What that means is, Mr. Melvin, when it's your chance to talk, just like previous hearings, I'm going to give you an opportunity to talk. I want you to just answer the question that's asked, though. If someone asks you for a phone number, I don't need to hear about history of abuse. That's not before me today. The only thing that's before me today is whether or not Ms. Hill should have telephone access. And that's the only thing I'm addressing today, and FaceTime access. All right, here we go. The court's on the record in cause number 18 DCV 253121 in the interest of Alana Milburn. Counsel, if you would please identify yourself.
My name is Wes Lindenbank, and I represent Tiffany Hill.
Thank you, Mr. Lindenbeck. Mr. Milburn, if you would please unmute and say your name for the record, please.
Gary Lawrence Milburn.
Thank you, Mr. Milburn. All right, anyone that's going to provide testimony today, if you would please raise your right hand to be sworn. Mr. Milburn,
Yes,
raise your right hand to be sworn. Do each of you solemnly swear or affirm the testimony you're going to give in this call is to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
Yes.
All right, thank you. All right, Mr. Lindemeck, this is your motion, which means you get to go first on your motion. I don't think I need an opening statement, but if you'd like to call a witness, you may do so, Mr. Lindemeck.
Sure, and I would offer, well, let me call Tiffany Hill.
Okay.
Tiffany, have you been trying to reach Mr. Milburn so you could talk to your daughter?
Yes, I have.
Did you provide us a call log about the times that you've called?
I have.
And is that we have marked as Exhibit 22, and we offer that at this time, Your Honor.
All right, Mr. Milburn, any objection to petitioners 22?
No,
Our petitioners 22 is admitted.
Okay, and from this, you've appeared to call numerous times. What number have you been calling?
His cell phone number.
Do you know that offhand?
Hold on 1 second. It's 281-323-2518.
2518.
Yeah, 323-2518.
323-2518. And you have, has Mr. Milburn been responding by answering his phone?
He has not.
And has he in fact, since you called numerous times, has he now blocked that number?
He has.
Okay.
I object, Your Honor. I have not blocked anything, man.
All right, you're going to get a chance to ask questions in a second. So don't object to saying she's not telling the truth. You can ask her questions in a minute, and you're also going to get a chance to tell me what you don't think is accurate. Objections overruled. You may continue, Mr. Lindemeck.
And you've also tried to do a video call. It looks like a duo. Would you explain to this old man what that is?
Yes, because Mr. Milburn has an Android phone, so I had to download that app to my iPhone, and he can use Duo. So I've been contacting him through Duo.
Has he ever answered your
Video,
duo
it's
call?
the video. He has not.
Okay. Would you like to also have some in-person time, say on a weekend with your daughter?
Yes, I would love that.
And isn't it true that you have not seen your daughter since the day in court when you exchanged them with Mr. Milburn?
That is correct.
And you have also not had a chance to talk to her
Nope,
or video chat?
nothing.
So in this period of time that you're in the penalty box for not handling things properly, you'd like some contact on phone. You'd also like some contact on with video, and you would also like to see her in person, like a standard visitation order or something during this time. Is that correct?
Correct.
I pass the witness, Your Honor.
Mr. Milburn, do you have any questions of this witness?
Yes, I do, Your Honor.
You may proceed.
Ms. Hill, are you and Mr. Milburn on bond conditions for no contact?
Not to my knowledge.
Actually admitted into the court. You said you don't know about it.
I'm not aware of your criminal cases because I'm not contacted, nor am I informed on what's going on with that. You go to court, I don't.
Okay, so you saying that you didn't know to the courts right now that there's no contact between Mr. Milburn and yourself?
Well, until now, you have her, but before you did not, so that wasn't even a factor.
I'm sorry, I didn't understand that, Ms. Hill. What do you mean by that?
Whatever order he's talking about, it wasn't a factor because he didn't have her, so I didn't need to speak with him. But now that he has her for a whole entire 2 months, something else needs to be put in place so I'm able to speak with her. I don't really care whose phone it is. or who meets me with her, but I would like to see her and talk to her since the circumstances are different.
Okay, so Mr. Milburn tried to do the same thing in the time that he didn't get any possession for the 7 months. So he tried to do the same thing.
As
Why
the
did
judge
you-
says, as the judge said, two wrongs don't make a right, and at some point things have to change. So if you continue to get me back, I get you back. Nothing is ever going to change.
We never had a problem, but we never have a problem because we've done this before.
Objection, Your Honor. There's not a question here. It's testimony.
Sustained. Just ask questions. You're going to get a chance to talk to me in a little bit, Mr. Milburn. Just ask questions.
What was it? Oh, okay, Miss Hill. In the event, have you ever called Mr. Milburn on a FaceTime, and has he ever let you talk to Alana Milburn?
Over the 3 years, we both have done the same until things get crazy, until I feel unsafe. I always follow the rules.
Objection,
But when
objection,
you-
Your Honor. Objection, objection.
Sustained.
So is it safe to say that in the event right now, regardless of the situation, like you said, that both parents need FaceTime and to be able to talk to the child without, on other parents' periods of possession?
I don't understand the question.
I think he's just asking that, do you think that it's in Alana's best interest that both parents get to FaceTime when they're not in possession of the child?
Absolutely.
All right, Your Honor, we could put that in the order. I don't have no problem. I just, like, my biggest thing was not getting in trouble for something. And it's clearly evident on paperwork that I cannot have no contact. You could use that against me in the court of law and say, hey, he's contacting me. I'm trying to do this, that, and the third. I'm not going out like that. That's the only, let's make this clear. That is the only reason why. That was not in any provisions or anything. Oh, most definitely. Ms. Hill knows that I've always FaceTime to let her know she see her daughter in the backyard having fun playing. So we don't have any problems with that.
Okay. Any more questions, Mr. Milburn, of this witness?
Oh, I did have one more question. Y'all can hear me?
Yes.
Okay. Ms. Hill, I did have one more question. The last time you saw your child, did you notice that your child had a fever, runny nose?
Objection and relevance, Your Honor.
Sustained.
No further questions, Your Honor. I pass.
Mr. London, make anything further from this witness?
No, Your Honor.
It sounds to me like we have an agreement to do access and, we have an agreement for FaceTime access. I can tell both Mr. Lindenbank and Mr. Milburn, and Ms. Hill, this goes to you as well. Your order that is currently in place that y'all are having to follow has major issues, and it needs to be modified and it needs to be cleaned up so that both parents, in my opinion, have better guidelines on kind of what's expected. And because I do deeply feel that both of you care about your daughter very much. And I think that if y'all have an order that addresses issues that protect her, but also protect each parent's rights as it relates to her, that we probably would be in a better position than we are today. I am granting FaceTime access. So I don't know, does an Android have FaceTime? I'm not a super tech guy. Ms. Hill, this question's for you, but if you want to be able to see your daughter on your phone when you call Mr. Milburn, I'm going to ask you the same thing, Mr. Milburn. But if you want to be able to see her when you're talking to her, can you do that through FaceTime on an Android?
I use a Duo.
So you have to use Duo.
Yes.
Mr. Milburn, are you familiar with Duo and what that is?
Yes, Your Honor.
Okay. So here's what I'm going to do to protect the fact that Mr. Milburn does, sounds like, still have a criminal case pending, and he probably does have a bond condition. And I recall him putting that in evidence previously that says he can't contact Ms. Hill. So his concern is that if there's a bunch of telephone calls to and from Ms. Hill, and it shouldn't be any to Ms. Hill, it should be just coming in from Mrs. Hill's phone, but that he could get in some kind of trouble with the court. So what we're going to do is I'm going to put a specific time period that Ms. Hill's going to call, so that she's going to have like an hour time period to call and talk to her daughter through Duo so that she can see video of her. Now, there may be times, Ms. Hill, during this hour that Mr. Milburn's out in the backyard playing with her and she's not like available as soon as you call. What's going to happen though is I'm going to put in this order that if for some reason Alana is not available, that Miss Hill's going to call back. I can't necessarily have Mr. Milburn contacting you under that criminal case, and I don't want to open the door for that. Typically, when I don't have a criminal case, if a parent is, giving a child a bath or eating dinner with a child, or maybe they go and they're watching a movie, then I'll have the parent that's currently doing something with the child, let them finish that activity, and then make it their responsibility to call the other parent so that the child, assist the child in making the call back to the parent once the child is available. What we're going to do is I'm going to give Ms. Hill, does 6 to 7 p.m. work for you? Between 6 p.m. and 7 p.m. each night?
Between 6 and 7? Yes.
Mr. Milburn, does between 6 and 7 p.m., is that a good time for you to be able to make Alana available when she's in your care? And we're going to talk about when she's in Ms. Hill's care as well, but is 6 to 7 a good time for you, Mr. Milburn?
Yeah, that's fine.
Okay, so right now the order is going to read that Ms. Hill is given what we're going to call telephone access or Duo access, which is the visual telephone contact. And she's going to have that daily between 6 to 7 on, we're going to do Mondays, Wednesdays, and Fridays. You know what? Let's make that Saturday. So Monday, Wednesday, and Saturday between 6 and 7 are going to be times that Alana must be made available. All the other days, so Tuesday, Thursday, Friday, Sunday, Ms. Hill, you are entitled to contact Alana during that period of time. I'm not going to make that part of the court order yet, because my hope is after today, Mr. Milburn's going to say, yeah, okay, I've got to make her available Monday, Wednesday, and Saturday. But Tuesday, Thursday, if we're not in some major activity, I'm going to let Alana talk to Ms. Hill. And Mr. Milburn, if you do that, it will go a long way with me, because you're doing something that is not specifically in a court order that I think is best for your daughter. And if you do that and you show me a pattern of doing that, that's going to help you. And Ms. Hill, I expect the same from you once this extended period of time is over. I want to see somebody be a bigger person in this case. And that means put their own anger aside, even though that's hard to do, and I understand that's hard to do. Put your anger aside, put the history that the parties have with each other aside, and make decisions for Alana's best interest. And I'm searching for a parent that will do that, because if I have that, it will make me feel a lot better as a judge going forward. And we do have modifications pending from both mom and dad. So the day is coming where I'm going to be able to fix y'all's order. And I want to know that I've got a parent, and hopefully two parents, that are going to do the right thing when it comes time to fix the order. And I know I have grandparents that are involved. I want as many people in this child's life as possible. And that's my desire. And that's what I hope happens for her. I'm not going to do physical access yet. I just think that based on the period of time that Mr. Milburn went without seeing his daughter, that there needs to be a period of time where, Ms. Hill, you kind of suffer the consequences of your conduct. And I know that's not something that you like. It's not something this court likes, but it's something that I feel is necessary so that you understand how serious I am about everybody following the court orders. So I am putting this in there. Mr. Milburn, make sure Monday, Wednesday, and Saturday, Ms. Hill gets to talk to Alana. And when she calls between 6 and 7 on the other days, I'm not going to hold it against you if Alana's not available. But I can tell you, you'll get a lot of benefits from this court going forward if you do the right thing. And when Alana's available, you let her talk to her mom on those days that are not specifically designated. I'm signing the order to this effect. Are there any questions from either side before we close?
No, Your Honor.
Mr. Milburn?
No, Your Honor.
All right, thank you. That concludes the court's ruling. Going off the record. Thank you all for appearing today.
Do we have a trial date that we can have to get this thing?
We need it.
Yeah, Your Honor, I'm getting my attorney. We getting ready to get on this, Your Honor. No, it's no rush because I still got, a month and a half with my child, and definitely we're gonna go ahead and get it set up as quick as possible.
Well, I
We've
think
heard that Mr. Milburn has getting an attorney many, many, many times.
Well, I think a trial date is very important, and I'm going to give you all a trial date because Mr. Milburn, you can contact Mr. Fagan's office and just let him know, hey, this is my trial date, and that way he can get up to speed on your case and get in contact with Mr. Linnemank, because hopefully the two of you can maybe come up with some kind of resolution amongst yourselves. But if not, this court will have the final trial on the modification. Just looking at dates. Give me 1 second. Mr. Linnemank, I'm going to go to you first. What is the week of? I have to give 45 days notice, so we're looking at August. So what does the week of August the 23rd look like for you? Could you do the 23rd, 24th, or 25th?
40.
I have I have a trial on the 23rd, but and the rest of that week is fine. And I don't think that's going to go to trial anyway in Conroe.
All right, Mr. Milburn, I'm looking at maybe setting this on the 24th or the 25th of August.
I don't think that's feasible. I really wanted to get it set up a week before July 31st because I really fear that Ms. Hill will go ahead and conceal the child again. So I really want to go ahead and do it like in the month of July. Because I really talked to my attorneys to try to get it in as soon as possible. That's what we're trying to do.
The problem is both sides are entitled to 45 days notice unless has there been a previous final trial setting, Mr. Lindenbank?
No.
I'd have to look at the docket sheet. In some ways, I thought we were hearing the modifications today, so we were quite prepared. But I don't think this had a 45-day notice on it, so I don't believe there's actually been a trial setting.
Okay. Okay. So yeah, I don't think from my memory, I don't think we've had a final trial setting where one side gave the other side, the initial 45 days notice that's required. I do want to get the case completed for y'all because I don't like the underlying order. I don't think it protects mom and I don't think it protects dad, and that's dangerous, especially when you have a history of issues on the case. So I would like to really tighten up the order for them. I think it will protect this little girl, and it'll protect both parents. So, with that being said, there's no way we can get it in July because we don't meet the 45 days notice that's required by the law. So I don't mind giving y'all the week of the 16th, doing it a week earlier, but it'll be sometime in August.
I'm open the whole week of the 16th.
All right, Mr. Melbourne, would you prefer to do the 16th?
I mean, yeah, that's fine, Your Honor. Just trying to make sure I get my visitation because we have Mr. Lindenback knows we got a problem with Ms. Hill.
No. We're not going to go into that. We're not going to go back into that. The court's very aware.
That's the issue. That's the issue with visitation.
Mr. Milburn doesn't want to hear my list of problems we have with this.
Well, and the court's very aware of the history, and I don't want to hear it 20 times. I'm aware of the history of the case and the issues that both sides have had on this case, and I can tell you that I believe Ms. Hill gets Alana back August the 1st or July 31st, that the first weekend, Mr. Milburn, that you have with Alana, I have a feeling she's going to comply with the court order. And I trust that the parents are going to do the right thing and they're going to follow the court order. And I think that's going to happen. So I'm not that concerned about that because I just believe that's going to happen. So we're going to set final trial for August the 16th at 9 a.m. Mr. Lindenbank, just so you know, if Mr. Milburn gets an attorney on the case, I would encourage y'all to mediate. If he's going to represent himself, I know with the history on this case, mediation probably is could be a waste of their time and money, and I'm not going to do that to them. But if Mr. Milburn has an attorney on the case, that would be my preference as they try to go resolve this so that they can address their issues with both having lawyers that know how to protect their rights and the child's right, and that y'all could maybe do that through mediation, and maybe come up with a solution that works for everyone without me having, or Judge Heppard, whoever's here in the trial, having to make those decisions for them. But Mr. Milburn, if you decide to represent yourself, just be prepared because August the 16th, we're going forward.
Your Honor, I already retained taking off. I already did. We just, like I said, we're trying to get the attorney. I will have him today.
Okay. Well, just let them know that your final trial is August 16th at 9 a.m. I'm making a document to that effect. I have signed this order from today with the telephone access. If the order's not followed, there'll be consequences. So just make sure everybody follows the order from today. All right, thank you.
And Judge, do we anticipate in August we'll still be doing Zoom, or what do we think?
I think that we're going to be doing Zoom probably until September the 1st is my guess. So I'm more than likely this final trial will be via Zoom. We're going to keep Zoom around for things because it just makes life easier on the parties, on witnesses, and on the lawyers to some regards. But final trials and enforcements, protective orders, we'll probably see those opening up in the fall is my guess. There's no clear rule yet. I think all three family courts are trying to do the same thing, so we make it easier on the lawyers. And so we've got to get kind of a consensus of all three courts on when that stuff's going to take place. Okay,
There's a lot that we've done through this that I hope that we keep.
I agree. I agree. All right, thank you, Ms. Hill. Thank you, Mr. Milburn. Thank you, the witnesses.
Thank you, Judge.
Y'all have a good day.
You too.